And we see labor and employment sort of always combined. And you hear labor and employment as though it's one topic or one idea, but it's not. Labor law is different. Employment law is either common law or statutory law. Labor law is very specific. But even in labor law, there's two sides to it. There's the public employment and there's private, covered by two different statutes, covered by two different agencies. And so let's start with public sector labor law. And Mike Clark probably knows more about public sector labor law than anybody I know, so I'll lead off with him. Mike, if you could just explain why public sector labor law is different and what's important that we know about it.
Well, thank you very much, and welcome everyone this morning for participating. I've had a pleasure of representing public and private sector employers in labor law for, well, just look at the color of the hair, okay? That'll give you some idea. I won't give you the total years. My focus is going to be on public sector, and my esteemed colleague Mike Bloom will follow up later on a little bit with what's a concomitant statute only on the private sector, which is the National Labor Relations Act and the National Labor Relations Board that enforces it. Many times we find, however, there's a real crossover between both the public and private laws that apply to labor relations and labor law. The Public Employment Relations Act, which governs public sector employment relations, is modeled after the National Labor Relations Act in many respects. So they're not necessarily antagonists to one another, but at times applied differently based on private versus public sector. The one thing that I think that is significant here, if you'll notice, PERA, which is PERA, and NLRA is the National Labor Relations Act, they're both four-letter acronyms. For all of you practitioners out there in labor law, it seems like we come up with a whole lot of four-letter acronyms without getting Tourette's. But the fact of the matter is, we have FLSA, we have FMLA, okay, we have ESTA now, ESTA. So we get used to these four-letter acronyms, but PERA, which is the most important piece of legislation that governs public sector labor law, actually is quite dated. It goes back to 1947 and primarily outlines both the do's and don'ts and the practices of dealing with public sector. And it guides us, if you will, on how we conduct ourselves, both in collective bargaining, in unionization, and so on. So what I have done, and I'm not trying to do a total primer here, but if we're talking about issues involving unionization, for instance, right now, in my practice, I'm experiencing what I call rival groups of labor groups coming in, trying to take over certain public sector groups. And if you are in an atmosphere in which you are already unionized, and you're in an atmosphere in which there is another labor organization petitioning through the MERC to represent employees that are already represented by another labor union, one of the keys to understand is that you have to go into neutrality. You have to not favor one labor organization over another, and you want to follow the very specific guidance from the MERC representatives who are going to handle all of that election process. Those petitions are filed, the MERC representatives get involved, they engage you in an interactive conference with both the labor representatives and, of course, management representatives. We talk about the makeup of the bargaining unit, and candidly, if you don't, I would recommend clearly that you have good counsel review anytime you're having an election process, the petition and what's being asked for and who is involved. Because the makeup of that bargaining unit, how it's described, is critical. And also, of course, MERC is going to determine who are the eligibles to vote, and they're going to determine when the vote is held. And most likely, as they're doing right now, most of it's done by mail ballot. So they'll determine a time for the election and how it's held, but they'll mail out ballots. And we have to provide as employers an Excel sheet list, which is a list of the names and addresses and information available to both sides, if you will, to have contact, if you will, with those who are eligible. And I've always indicated to my clients that, look, be very, very careful during this process. Whether you already have an existing union or for the first time as a public employer, a group of your employees are seeking to organize, that you get your managerial employees aside and you counsel them very, very carefully about this concept of neutrality. Because you're going to have employees that are going to come to management representative, I don't want this labor group, or, well, I want this labor group. Well, we don't want to participate as management in their decision-making process. We've got to stand back and put that shield up, okay, to protect the employer from what would be considered interference or coercion or efforts to determine the outcome of an election. So all the things I hope that you walk away today, if you have any time that there's an election issue, is to get your managerial people all on board with that concept, that we just don't favor one or the other. Candidly, and in many respects, I think once you have a contract in place, as much as you may or may not like labor organizations, it becomes your template. It becomes the tool by which you manage your workforce. And it's really then, in my opinion, not us against them. It's a process by which we proceed to have an exclusive representative of their employees, bargain on their behalf, deal with their grievances, handle wages, hours, and conditions of employment. Generally, of course, if we're involved in just routine atmosphere with MERC during the year and we have a contract in place, there's a 60-day rule that we notify MERC that, the bargaining is about to start. It used to be that MERC would immediately then appoint a state mediator. They would assign an individual, a state mediator, to assist us. Well, now we file our notice and MERC doesn't send anyone, they don't send us a list, and they just wait. And they say, if either side ultimately needs a mediator, we'll then appoint. And obviously the state mediator gets assigned, and generally by jurisdiction. State mediators, depending on their skill levels, can be extremely effective, in my opinion, in helping parties if they get to impasse. They come up with various ideas how to resolve the disputes. The one thing that is true is that they can't bind you as an employer. They can't bind the union either. So they're there to assist and broker, if you will, a deal. And that's the same as if a mediator is involved and appointed in a grievance meeting. They can come in and assist the parties. MERC will assign a mediator if requested to handle the grievance, but they can't bind either party to a recommendation or a decision. They carry weight, and a lot of times we can throw their weight around and we can indicate that here's a mediator's recommendation, both to a settlement of a contract or settlement of a grievance. And you may say, well, let's just delay a little bit, if you will, in resolving this today and go back to the respective principles and say, a mediator, a third party out there is recommending this. And maybe it's different than the authority you perhaps will have at the bargaining table or that you might have in the resolution of a grievance. And you go back to your principles and you talk about it and you say, hey, maybe we should take this recommendation at heart and resolve the dispute one way or another. So I've always said that's basically in part the affirmative negative, which I've always said works really beautifully at the bargaining table as well. In public sector bargaining is that, I understand your proposal. I can't agree to it because I don't have the authority, but let me go back and talk with my client and see if there is some method by which I can address your proposal. And what that does is you depart the table with dignity on both sides, and it doesn't create acrimony, because generally it's been my experience, acrimony does not resolve disputes, either in grievances, nor does it resolve it at the bargaining table. So PERA has some pretty significant do's and don'ts in it. And I've outlined a few of those, at least, and I want to give you a couple of those. But one is, as an employer, you can't initiate, create, dominate, contribute, or interfere with the formulation or administration of a labor organization. Okay, that's going back again to that neutrality concept I talked about earlier. You can't discriminate against employees who wish to be in a union. You can't refuse to bargain with the representative that's chosen. There's a concomitant part to that. It flips over to the unions. They likewise, they have to bargain with you, and they can't refuse to bargain. One of the things that I have experienced, and that is specifically prohibited under PERA, is a labor organization will try to get rid of your spokesperson. They don't like Mike Cluck, they don't like Courtney, they don't like Cliff, they don't like Mike. Okay, they want that bugger off of the bargaining table. And if they start down that road, that specifically is prohibited under PERA, that they cannot in some way coerce or restrain, or if you will, the employer's determination on who it wants to have at the table representing the management. And so those are some of the preliminary do's and don'ts that exist in terms of PERA as it's applied. We've gone through this whole sequence, of course, of changes in many of the public sector labor laws, and most recently, of course, we had the right to work law changed in Michigan, which resulted in with employees now being capable of being mandated to be in unions, but that does not apply to public sector employees. So the Janus case involving AFSCME union clearly determined by the Supreme Court of the United States that the public employees cannot be mandated to be in a labor organization. So I don't see that being reversed in probably my lifetime anyway, but nevertheless, that's your guiding principle, that your public employees cannot be mandated by any labor organization to support that labor organization. So one thing too, I think is significant when you're at the bargaining table that PERA says is, look, you got to bargain at reasonable times. You got to bargain at reasonable places. But the statute says neither party has to concede to a position from the other side. So, that's the case. You can't simply be coerced into a resolution. I mean, there are dispute resolution mechanisms, of course. So if you can't get it done at the table and you have mediation and that doesn't work, for certain bargaining groups, of course, you would have fact-finding capability, all of which is non-binding. It's a recommendation, but nevertheless, it's an extension of bargaining. And I won't even get into police and fire because they have mandatory compulsory interest arbitration, and that's entirely different, a whole different part of the public sector. So if you, as an employer, or if the union as a part of a labor organization step over these lines, they're addressed by these documents called unfair labor practices. And I have to tell you, folks, from my experience, the time is well spent avoiding ULPs, because they're going to require a hearing. They're going to require a determination. If it's adverse, it has to be posted. So to the extent that you want to comply with the statutes, it's very important to try to stay out of administrative hearings and use your money and your resources at the bargaining table and in the grievance processes, because those are the best forums for resolution. It is not to have an ALJ or administrative law judge say, oh, you guys stepped over a line and you committed an unfair labor practice. It's not a comfortable feeling. So preliminarily, those are my remarks. I really think that, PERA overall, I think started out at just basically public employees can't strike. And so that still was true when it was adopted, it's true today. And so that's the one thing, at least, that we generally can avoid in the public sector, is we don't have employees that can go on strike. So those are some of my preliminary remarks this morning, and to the extent that questions come in later on, I'll be happy to try to answer them. I get lots of questions every day, everything from who could be at the table, who should be at the table, et cetera. So,
Okay, thanks, Mike. Courtney, I know that you do quite a bit of public sector employment law as well. You have quite a bit of experience. Anything that you would like to add or comment on what Mike has already said?
I just want to echo what Mike said, that I think the biggest way to achieve success at the table, start early, be respectful, know the collective bargaining agreement that you are dealing with and the union that you're dealing with, because each one is made up so differently, right? Depending on the type of work that they're doing, the hours that they work, all those different things. And just be prepared to come in with an open mind, because you know, as much as I'd like to think that public sector is similar to private, it's just so unique, right? And you work with these folks every single day. So come to the table, be respectful, be prepared for, having an open mind, and just have those hard conversations. Because I agree with Mike, you want to avoid arbitration if you can. You want to avoid something going to MERC if you can. It's just a long, unnecessary process when you can have those hard conversations at the table. So those would be my biggest contributions.
Okay, thanks, Courtney. All right, now let's shift over to the private side. And we could take a considerable amount of time on that if we had it, which we don't. I am actually doing a presentation next week on the private side labor law, primarily the NLRB decisions and whatnot. And I have an hour unto myself on that, which I don't have today. But I do want to cover some of the big issues confronting private sector employers, and I'm going to ask Cliff for his opinion on this. Cliff and I do quite a bit of our firm's private sector labor law, and we work very closely together, and we've been monitoring this. But there's three areas that I think we want to make sure we touch on and explain where the law currently is. One has to do with the election process. One has to do with workplace rules. And the third one deals with who can be liable, joint employer standard. So all three of those affect employers, whether they're union or not. So it doesn't, I mean, if you have a union or if you don't have a union, don't make that decision as to whether you want to know about these areas, because it's going to affect everybody. But let's just start with the election process. You're non-union right now. You think all the employees love you. You get somebody walking in the door and they say, I'm from your friendly union down the street, and we think a majority of the employees want to be represented by the union. We demand recognition. The question becomes, what do you do? And not that long ago, I would have told them to turn around, don't let the door hit you on the way out, and do nothing, and then prepare for it. There's a decision that is called CMAX construction that probably makes that really bad advice. And what CMAX does is it says when a union makes a demand for recognition, employers have three choices. They can recognize a union instantly, which I also would not recommend, by the way. Within 2 weeks, they can file what's called an RM petition for an election with the NLRB and test the claim of majority status. Right now, the burden would be on the union to do that, or before CMAX would have been on the union to file the petition. Now, all they have to do is say, we want recognition, and that burden is on the employer. And if you file that RM petition within 2 weeks, the NLRB will conduct an election and see if the majority claim of majority support is true. Or you can ignore the request and see what happens. That would not be advisable either. Why? Because if there is majority support, doing nothing and not bargaining is an unfair labor practice. And your only defense to that is going to be to establish that in fact there was no majority support. If there is majority support and you do nothing and you don't start bargaining, you have committed an unfair labor practice. So you've got to be aware that any demand for recognition comes with a need to immediately take action. And that action generally will be filing a petition with the NLRB. Now, who does that demand come from? Can it come from anybody, or does it have to come to the president, or made to somebody high up? The answer is no. It can be to any agent or representative of the employer. So this could be any supervisor in a plant that they're organizing that 3 weeks later says, "Oh, by the way, this strange person came in and demanded recognition. I told him to leave. So I just thought you should know." Well, that's going to be a problem because that's a demand on an agent of the employer. So you really need to make sure all of your supervisors and managers are aware of this change in the law. Another big area is with the workplace rules. And the workplace rules, they come under Section 7 of the National Labor Relations Act. Section 7 doesn't protect union activity. It concerns protected concerted activity. Concerted means more than one, although that is been changed because it's not involving directly two employees. It can be any discussion that could affect more than one employee. So it could be any concerns that could affect the group as a whole. And we've seen changes in the law in that area. There's a big case that came out of COVID, concerns over what the workplace was doing in response to COVID was found to be concerted activity because the COVID affected the entire workforce. So protected concerted activity is pretty broad. And the workplace rules, there's been tests, they've been going back and forth depending on who is in the White House. Right now, the law that covers the workplace rules is Stericycle. It was decided August 25th of 2023. It overturned what had been kind of the standard in Lutheran Heritage, and it changes the test. So to rebut a presumption that the rule is unlawful, and yes, I said that right, there's a presumption that if somebody feels that the rule prevents them from engaging in any activity to improve their wages, hours, and working conditions, which is the Section 7 rights, if they feel that that rule won't allow me to talk to another employee about my wages, it won't allow me to talk to other employees about fill in the blank, that's presumptively illegal. And in order to defend against that presumption, the employer has to show that there's a compelling business reason for the rule and that a narrower rule would not achieve the employer's business objectives for the rule. So a pretty high bar compared to what the prior rule was. And there's a number of cases that have developed through the years and giving us some real life examples on how this has played out or likely will play out. And examples of rules that were found unlawful is disrespectful conduct or insubordination. Too broad, illegal. Chronic resistance to proper work-related orders or discipline. Too broad, unlawful. A rule that says be respectful to the company, other employees, customers, partners, and competitors. No, can't do that. You can't have a rule that requires that employees be respectful to the company. The NLRB says that's too broad. It chills employees' Section 7 rights to criticize the company. Do not make fun of, denigrate, or defame your coworkers, customers, or suppliers. can't do that, can't have a rule like that, you know, if he doesn't like it. Be respectful of others and the company, also unlawful. So I'm giving you some real life examples where the NLRB has found rules to be unlawful. And with that, I would suggest only that you go into your handbook, go into your policies, and take a good look at them and probably get with legal counsel, because this new rule has tightened up what will be permitted. And if there's a violation, then any action you take in enforcing that rule is going to be an unfair labor practice. So I'm gonna, that's a real brief summary. And in the, I apologize, we can't get into it any deeper because of time. But I am gonna ask Cliff if he has any comments in addition to what I made on CMAX and Stericycle. And I'm also gonna let Cliff briefly touch on the joint employer standard.
Yeah, thanks, Mike. I agree 100%. I think, though, the way I look at this, in addition to what you said, is imagine you see a hurricane in the middle of the Atlantic and you live in Florida, okay? You've got some time. It's coming. It's going slow. It's powerful. It could knock us out, but it's okay. I think a lot of times what employers do is they look at a non-union employer especially, they'll look at that hurricane and go, okay, I got time. I got plenty of time. Now, when that thing starts tracking and the cone's going to shift and you don't know if it's going to hit you, that's not where we're at with the sick leave law. And that's not where we're at specifically with this change in the law that Mike just described. It's now. The hurricane is here. You are being hit. It is not the future. It's today. And if you're not union, you're still held to the standards Mike just described. And I can't make that any clearer. This is not a union law. This is employer law. Private sector employers, if they have rules like the ones that Mike said, which I bet you 90% of you have, something like that, you're in violation of law. If you discipline somebody and they go down to the NLRB, not because they're union, not because they have a steward, and they say, you fired me because you had an overly broad rule under this new ruling that came out in Stericycle, you can get your job back. You can get back pay, and they don't have to pay a dime. There's no attorney. The federal government will pay for it, and they have the full force and resources of the federal government to come after that employer. You have to review it now. The same thing goes to CMAX, and I don't know if people properly understand how unbelievably different this is from what you've ever heard of before. If an employer is sitting there, non-union employer, the old way to look at it, I know this because I used to be on the union side, and I used to do organizing, and I used to do campaigns. You would always go out and get 60, 70% of the people to sign that they want to be part of the union. Then you would go file with the NLRB for an election if the employer would not recognize you. That's how it's always been. This changes everything, and it's changed today. If, like Mike said, somebody comes in, has a list of people that, and they say, listen, we've got majority support, and they tell it to your lowest level manager, and you don't do anything in 14 days, you're unionized. Period. It's not a matter of elections. It doesn't matter. You didn't do anything. You sat on your hands. And if you don't mind that, that's fine. I mean, whatever. But if you do mind now having to negotiate in the interim over every discipline that you take, because you can't just take discipline on an employee all of a sudden if you have that. That's a fundamental. There's no election. There's no process. Now, you can try to fight that they didn't have majority status. Of course, it's illegal to ask people, do you support the union? That's actually an unfair labor practice. Are you in favor of the company, or are you in favor of the union? And a lot of people don't even know that. So you have to train and educate your manager so they know what they're doing. If you do have an election, if you do file or the union files, one thing that's very clear now, this is a fundamental difference. If there's an unfair labor practice, let's just say you discipline somebody under one of these reasonable rules that Mike said that actually are unlawful now under the way they've interpreted under Stericycle, that's it, election canceled. You now have a union, you're in. If you violate the NLRB, if you commit an unfair labor practice, there's no need for an election under the new rules. We simply suspend the election, set aside the election, no reruns. You're most likely going to have a union. So it's now, it's not in the future. So if you haven't trained on it, there you go. If you are a unionized facility, what this says is you're probably okay most of the time, but if a person or the union says that your work rules, even if you've negotiated for the right to promulgate work rules, if they're still too broad, they can just go ahead and file at the NLRB, and we can argue whether or not it's covered by or not covered by the contract and subject to grievances, but just beware of those kind of concepts. The next issue that Mike was alluding to was this Atlanta Opera case, which is a pretty interesting case. What it did is basically reset the table and said, look, let's just say you have temp employees that come in from a temp agency and they work side by side and you pay them, whatever, a contract to be a temp agency, and they're getting $3 an hour less than the people they're working that are full-time company employees. They might not like that too much. They might drag a union in. And historically, you've said, look, different employer, right? That's a temp employee, not my employee. And so if they want to unionize, that's fine. They can unionize their employer, but not me. And they said, well, wait a minute, wait. They may be jointly employed by you and that temp agency because you have control over that person's terms and conditions, at least some of those terms and conditions, because maybe the HR duties, maybe this, the certain benefit packages and who pays their pay may be the duty of this company. But if you get that person, that temp in, and you say, hey, go over here, go over there, do this, do that, that may be control. And if you can fire that person under the contract to say, hey, temp agency, don't bring that person in here anymore. I don't want them. They're a troublemaker. Even if you have that in the contract and you don't exercise it, even if you could do it, not that you did exercise that authority, that person potentially could now be, under the new standard, jointly employed, and so they can get that person to sign a card or participate potentially in an election. So it expands who it is to be an employee. And we've seen this independent contractor issue go into the concept of classification of employees. Who is an independent contractor, actually independent contractor, is the person your employee. And there was a fight a couple of years ago. The NLRB had brought some charges saying if you misclassify a person as a 1099 contractor, although historically that wasn't an unfair labor practice standing alone, they started bringing cases saying, actually, that's an unfair labor practice. You're actually restraining that person by not making them a true W-2 employee, that you shouldn't make them a 1099. And now that's fast forward into what we've seen now with our athletes at universities, actually employees. So we're starting to see this ramp up. This happened before. What we're looking at, though, is a byproduct of the concept of who is your employee. And what's happening is the NLRB is making it broader. The rules are broadening and consistent. So you need to know who's your boss. You need to know who's your employees so that you can articulate, if you ever have a petition or if you have a unit clarification, what's going on. So the storm isn't coming, the storm is here. It's a significant change in everything you do. You literally don't have to have an election to have a union anymore. You get what they call bargaining orders. So very important to keep on top of this stuff, to review your handbook, and all the time, because there are decisions coming down. I'll give you an example. In addition to what Mike said, there are social media policies out there that say things such as making negative comments about fellow team members and engaging or listening to negativity or gossiping, or don't use the company logo for any other reasons. All have been found to be unfair labor practices in the context they were written. Now, there are ways to get around that, but you have to review your handbook. You have to review your training, understand what your obligations are, because if employees, managers don't know, you could have a union and you're negotiating with the union, and you are in. And it is a little bit like the Hotel California. With a union, once you have a union, it is extremely difficult with very small windows for the employees not to be unionized anymore. So we have to be very careful with that.
Okay, thanks, Cliff.